how can you find out if the vessel is suitable for this charging, loading of goods?
It's important that you know good people to help you, like shipbroker, agents, surveyors, and everything. Yes. If you are buying and the goods are coming to your country, I recommend you to make insurance in your own country, because then you have control of your insurance broker, you have control of the insurance company, and it's easier for you to claim from this insurance rather than the Chinese one.
Welcome to the Maritime Vision podcast. I'm your host, Paul Wioli. In each episode, we bring you exclusive interviews with maritime professionals, industry experts, and students. Our guests come from different backgrounds, including shipping, yachting, offshore, supply chain, and more. Our goal is to give you all the knowledge you need to succeed in the maritime industry.
Hello everyone, welcome back to a new podcast episode. And today in this episode we are joined with Gerson, so this is the second episode with you. So last time we talked about ship owner, charterer and charter agreements in terms of maritime law. So today we're going to focus more about cargo, freight and commodities law. So it's quite interesting topics as well for like shipbrokers, commodities traders, but as well young maritime professionals who wants to know more about this industry. So today we are at STC building. You can see behind this nice view on the Maas River, which is one of the, I would say, the artery of the European shipping traffic. So I'm very glad to be here with you. So let's maybe first, I won't introduce yourself, but maybe you can make a short introduction for the people who didn't watch the last episode. So can you shortly introduce yourself, please, Gerson?
Yes. Last time and this time we are going to discuss and we are going to examine some problems arriving not only for the shipping community but also for the commerce as a whole. And you cannot draw the line between what is shipping and what is foreign trade, because they are so much entwined together that it's impossible. I mean, there are so many institutes that belong to both of them, like many contract provisions, for example. They belong to charter parties and to sale and purchase, for example. Some precautions, some legal aspects, of course, and yes, what is the present picture now? Rather bleak for the importers and exporters on container, but let's go ahead.
Okay, so of course I'm going to ask you the first question. So which are the main concerns for a prospective charterer or buyer-seller of manufactured goods carried by containers? Because today it's quite a critical problem, I think, especially in the trade of consumer final and manufactured goods worldwide. So what are the most which are the concerns?
I would say there isn't a problem for the charterers, because the chartering in that trade, actually it's a line trade, is for slot chartering, and so they understand each other, the ship owners and the slot charterers, the lines. The problem is the client, the receiver of bill of lading, receiver, consignee, and shipper, and the carrier. The carrier can be, of course, a slot charter or the ship owner. Let's call it lato sensu carrier. What is happening is that the cost is becoming draconian. The lines, they are becoming more and more abusive, I must say. And I don't know if you know, many of them don't even pay income tax. They are benefited already. They pay something called tonnage tax. per the tonnage they carry or per the tonnage of the ship, not what they produce. And still, they're making quite a lot of money in that trade because they are every day they come up with a new tax, a new charge. And the problem also is that you may see your cargo, if you are an exporter, not being shipped when you want it, right? Or if you're waiting for a cargo, not arriving when you want it, not even by near. So my suggestion of precaution to a trader of manufactured product carried by containers is that they should duly inform their business partners and put in a contract that they will not be held liable for delays caused by the carrier, by the sea carrier. And I know sometimes there is no contract. If there is no contract, then exchange of emails is enough. But be sure that you receive a response or acknowledgement of receipt. Otherwise, there will be a problem, not only to your own forwarding clients, but also to your supplier. Yes, that's one thing. The other thing is that you can, as a client of a line, frustrated, go to court to complain about this and that. They left my cargo. They're charging abusively and so on. You may even succeed, but you may, at the end, lose because you may be blacklisted by the lines. Therefore, I only foresee one solution for all. It is that all the traders of manufactured products should get together in their associations, go and lobby their legislators in their countries to protect yourselves. Because the way it is now, the companies, the shipping companies are doing what they want. And the smaller you are, the worse, or new. Of course, the traditional shippers and receivers with big volume, they will be favored. And if you are new or small, you'll be left at the end. You'll be the most damaged. So the solution ends up being political rather than legal for this situation. It is getting very, very bad. I'm in contact with the shippers and receivers, and they are a general complaint about it. Right.
About these general complaints, that lines are becoming increasingly abusive because with the charges of demurrage, detention, etc. I mean, do we have like other kind of big cases in this business of container cargo?
Yeah. A case passed to me $1.5 million of demurrage and detention and storage.
Okay.
They know, the lines know very well that they've been abusive because more often than not, if you go knock at the door, say, look, I cannot pay you, it's too much money. Oh no, at the end they accept 1/3 of what they are charging. But you have to be firm.
Okay, interesting.
And be careful not to be blacklisted.
Okay. Okay. How can you be blacklisted? If you don't pay, or
You will be blacklisted if you are a troublemaker and if you don't pay, of course.
okay,
Or you start one legal or more than one legal action
Okay. And how it works, this blacklist? Is it official blacklist or it's like just a
Of
word
course,
of
it's
the
not
mouth?
official. It's
Oh,
not official.
it's word of the
The
mouth.
blacklist is not official.
Yeah. Okay. Not talking about trade commodities. Uh, in our last meeting, we talked about demurrage. Like today, can you explain a little bit about cuisines of the demurrage, which are, for example, you mentioned a customer quick dispatch on opposite, let's say the opposite demurrage, which is carrying charging.
Yeah, sure, no problem. The CQD, customer quick dispatch, yes. It is much better, much more flexible, and infinitely less costly than the merge for the shipper, an exporter, or a charter, of course. You must have in mind that you and everybody else, that nearly all trader of commodities are voyage charterers, right? The CQD I see being applied in the trade of steel, traditionally steel products. I don't know if other products are, but I only see it in the steel products. And there is it's not a liquidated damages, as they say, for the moorage per day, and you pay 6,000, 20,000, 25,000 if you are delayed. No. Actually, a delay as such only can be charged, and they call it detention. They don't call it demurrage, detention. If the receiver or the shipper is evidently negligent. Otherwise, no. If there is something extraordinary, like force majeure, for example, no, nothing. For example, there are many cases like this. You are discharging. You are the receiver. You are discharging normally to train wagons. Train wagons are not available this time. So you are expected to use other means of transportation, like trucks or barges. But even so, if trucks and barges are very expensive at the time, and they may take advantage of the situation, put that price. Even so, it's not a matter to be claimed. You, as a receiver, still will succeed. So that's a very good. It's a very kind, let's say, a very kind cousin of the merge. This CQD.
So, what is the difference with, because you said it's cousins of demurrage,
Yeah.
but what is the difference with the CQD?
I say cousin because at the end it may be charged for delay if the shipper, receiver, charter is negligent and really caused the demurrage. But that's exceptional. That's why it's the very kind cousin of the merge.
Okay, and what about carrying charges?
The carrying charges is an institution, not in shipping, It's only for the trade, for buyer and seller. It happens between buyer and seller when the seller is selling FOB, free on board, so he's waiting for the ship from his buyer to arrive. If the ship arrives late or for some reason does not berth, then the seller can charge something called carrying charge, which is taking care of the goods in port while waited for the transportation. And it has got to be charged if there is, of course, a provision in the contract of sale and purchase. There is nothing in the charter party, for example, because it's nothing to do with the ship owner. Now, the ship owner's got to do with the charter in case of a laycan. If the laycan is not accomplished, then they have the choice to give up the voyage or renegotiate. But that's something else. The buyer and the seller are not interested in this. This side. So that's it.
Okay, quite clear. Thank you. No. Oh, I want to ask you another question. How can you find out if the vessel is suitable for this kind of discharging, loading of goods?
In the other lecture, remember I told that the contract of buying and selling and the charter party, they are completely free. You can do whatever you can negotiate. You can put there whatever you want. It's not like a bill of lading at all. Of course, it's got to be a legal object, not obscene, not incredible or anything. Apart from that, this legal restrictions, you are free to negotiate whatever you want. So people tend to be conservative in a way, especially traders. If the trade of steel products is under the CKD, then they go on like this. And so if one day a seller is selling cost and freight, and he's going to charge demurrage in the contract of sale because the ship owner also wanted demurrage, then that will be. I mean, that also depends on the demand, that depends on the commercial interest. If you need that good so madly, then you accept it, but you don't have to, you know?
Okay, quite clear. Quite clear. Now let's talk a little bit about the dry bulk grains market. Can you talk a little bit about precautions of loadings of grains in bulk as it needs fumigation to avoid insect infection?
If you are an exporter of grains, if you are, so many people is involved in it. Sometimes even the importer, I will tell you why. If you are the captain, mainly, if you are the surveyor appointed to supervise, and especially if you are the entity that is fumigating. Because fumigation requires special care to avoid damage to human life, to start with, explosion in the ship. It happened in my case. I had 2 cases that it did explode, and if it's not well done, if it's too much, it may explode, depending on the humidity, depending on the temperature. If it's not enough, it may happen what we call ray infestation or infestation. If that happens, and then the vessel destination needs to be fumigated there because the authorities want so. So you have to spend at least 5 days, you, captain, have to spend at least 5 days moored, waiting for the effect of the fumigation, and the gases go away for you to discharge. So then you can have 5 days demurrage. Yeah, and whereas on the case of explosion, not to mention damage, human damage, personal injury, the shipowner may have a claim against many parties. The shipowner may have a claim against the shipper, against the institution that fumigated, the surveyors, whoever else. And I have a curious case, because what happens is that the fumigating substance was out of date, and it was performed by a company recommended by the buyer, by the receiver. He said, I want this. Okay, you recommended it. We just followed. We didn't want this company. So all the losses will be on the importer. So that's what I said. Everybody must be very careful with this process of fumigation, which is unfortunately, it's necessary in any shipment of grains.
That's the next topic.
Yeah.
Equus. Let's talk about Equus. I think it's very unknown in the industry, but it's still, it's a very powerful tool. So first of all, this tool is very powerful because you have access to vessel history. You can see all inspection on board, every incident. So it's very powerful for like brokers, for lawyers, for experts to understand everything regarding the life of the vessel. But can you explain us a little bit how, like for example, a shipbroker or commodity trader can use on what is the goal of this powerful tool, I would say?
First thing, as a lawyer, my concern is that who's the shipowner, who's the manager? Because the ultimate shipowner, the registered shipowner, which is in Monrovia or in Panama, is a company, one shipper. You have to go against them if you need. And through the manager, so it's there in Equs. Their names are there. So that's one thing. The other thing is that the age, of course, if you really want a ship not older than 20 years, then it's 23, no, I don't want this one, and so on and so forth. And you have to see deficiencies. Every ship has deficiencies imposed by, marked by the port state control in every port. But let's see how serious they are, that detention of the vessel is required. Now, I have a case, a concrete case, wherein she was detained for 10 days, and she had 17 deficiencies. So this is really, as you know, in your profession, it's a no-go. Yeah. It's a no-go. And then anyone can be a member or registered at Equs. It's free and it's very convenient.
So I've seen few features, like for example this history on the inspection, everything. Do we have more? What are the features on this Equs?
Yes, of course.
Kind of information.
You have the history. What was she named before that? And I said all the casualties, arrests, and so on. Arrest, I'm not sure, but detention by the port state control. And you know, the port state control is an entity very close, if not a part of the IMO, International Maritime Organization. Yes. Another thing, not only Equs, it's a consultation by mouth. I mean, let's give an example. I have a client. He was importer of cotton, and raw cotton, and every time he was buying, he consulted me about a certain ship, and then whatever I found out, I told him. Usually it was okay. You see also in the Equs whether the ship is duly classified. It's a good classification society. good P&I club, and so on. And then I'll say, okay, take this, I give it 6, 6.5, I give it 9, and so on and so forth. One day, they forgot or they didn't consult me, and they phoned me desperately, say, look, I have a vessel full of cotton, and I need it madly for my line of production. The owner has no money for the wharfage, for the pilotage, for wharfage, for fresh water, for food, for salaries, for nothing. And then I asked her, how long is she from the coast? I said, oh, okay, 10 miles, something like this. I say, right. And how much you need this cargo? He said, immediately. I'm desperate. I said, well, then, what you do is you press your seller, because he chartered a bad ship. See if he can afford, or if he is willing to afford all the costs. Meantime, contact your agent in the port, and ask him what will be the cost of everything to have this ship berthed and discharged. Because the most important for you is this cargo. So he said 60,000, and at the end, the seller agreed to pay only 30,000, alleging that, oh, you see, there's this premise that when the cargo is put on board, the risk passes to the buyer. I said, yeah, but now there are 2 exceptions for you to remember. First, inherent vice. Inherent and hidden vice. I mean, it's the cargo is not regular, it's not in order, and no one knew about it. Maybe the shipper only. The other thing is the negligence of the seller charter. I told you that every trader every voyage charter is a trader. The voyage charter seller selling custom freight was negligent by choosing and hiring this vessel. So you have the alternative to go to either of them, the ship owner, or your supplier, or both. Yes. So this 2 exceptions is very important for the seller and buyer to know, to protect themselves or to use them against somebody, One is the inherent vice. The goods were shipped already defective, wet because of rain on the wagons or something, or the shipper was negligent to engage the wrong vessel, to fix the wrong vessel.
Okay, quite clear. Wow, it's a huge case. So, which kind of commodities is the most, I would say, subject to law on issues, concerns in terms of dry commodities? Is it more grains, more like steel, cottons, iron ore?
It's in this scenario of commodities, there are very safe, very solid commodities, like sugar, for example, might be some damage to the big bags, so the interior is damaged as well, not fit for consumption. But most of the problems is in the grain, because there is some they are too burned, or there is some That sometimes it happens, contamination on board with oil. What else? There are dangerous cargo, of course. For example, fish meal is subject to combustion. Fibers are subject to combustion, like sisal, for example, cotton. They are more susceptible to damage than the steel products, for example. Steel products, they may be rusty, they may be bent or thing, but not much. And of course, remember last time we talked about liquefaction of minerals.
Yes.
That's very, very important. You have to control how, not when I say you, I say everybody. The captain and the shipper. They have to be very careful, because they can both be held liable if something happens to the ship, because the cargo liquefated.
Okay. Now I just want to clarify because okay, we have ship owners, we have charterer, but you have these intermediate people like shipbrokers, the traders. What are their goal as if I want to be a good shipbroker or a good trader, what should I do in order to avoid this kind of cases, issues, and to assist my stakeholders like charterer or ship owner?
Yeah, the human factor is very important. I mean, it's important that you know good people to help you, like shipbroker, agents, port agents, surveyors, and everything. Yes.
For now, I think we are quite we cover quite like wide topics about the commodities trading in the world and the law, etc. Maybe I forgot to ask you one question regarding Incoterms.
Because, just to remember you, what I said about the liability of the seller selling, he must be a cost and freight or cost insurance and freight seller. We are in the Incoterms. We are in the trade, not in the shipping directly, but in shipping. If he's liable, it's because Article 32.2 of the English law, Sale of Goods Act, 1979, and the Vienna Convention, the UN Convention of 1980, by coincidence, is also Article 32.2. They hold the shipper liable, the shipper that was negligent to appoint a deficient means of transportation, not shipping only. Could be airplane, could be truck or barge.
Okay, interesting.
So that's in the INCO, because it's got to be a seller, which is CIF or CFR, but also by the law, international or English. Why do I mention English law? Because English law is so popular in shipping, 90% and or more, and in the trade as well, at least some 50%.
Okay, interesting. But it's quite connected what I want to ask you because you know this Incoterms 2020 we have the FOB, FAS, CFR, and CIF. So sometimes when you pass the goods from the seller to the buyer, you can have some issues in terms of insurance on claims, damages, how it works. Because, for example, I'm the charterer, I'm going to give my goods to the ship owner. So if I am FOB, it's depending the Incoterm issues, but you have different kind of who is responsible for what. Is it like always accurate, this kind of responsibility switch?
Yes, you have no responsibility at all if you're selling X works, and then you buyer takes care of everything, not only the costs but the risk. And then you have the delivery at place, DAP, where the seller is liable for everything, because he wants to, for some commercial reason, of course, because the buyer said, no, I just want my goods here. You pay for everything, you take care of everything, including the customs clearance, and I want the goods here. Then I pay you what you want. So those two extremes, and then in the middle you have the FOB, free on board, and the CFR, CIF. Now, the CIF is one characteristic that the insurance is to be arranged by the seller. The buyer may find it convenient, but I don't recommend. If you are buying and the goods are coming to your country, I recommend you to make insurance in your own country, because then you have control of your ship broker, of your insurance broker, you have control of the insurance company, and it's easier for you to claim from this insurance rather than the Chinese one. If you're not in China, of course. There are some other variations, but not very popular. The most popular, I must say, is this FOB, FAS, free alongside ship, which is nearly as FOB, and cost and freight, cost insurance and freight.
Okay, quite clear. Thank you, Gerson. I think next time what we should do, and if we want to make another episode, it shouldn't be an episode, it should be a live session where people will directly ask you some questions. Because I think it's very important for everyone. Sometimes they have their own questions to ask you. So I think it would be a nice concept for the third, if you want to make a third episode of it.
Yeah, but you're doing a good job, because you are abstracting yourself, imagining how a trader, how a charter would have doubt, how their doubts would be.
Yeah.
So,
Yeah, that's what I want to.
it's not easy, because many things does not occur to you,
No, that's true.
only in the day-to-day life.
No, but that's why I'm quite very curious about how it works, everything on these intermediate people, or they can use their expertise to assist ship owner and charterer. So, but thank you, Gerson. Thank you for this episode. Of course, I wish you all the best.
Thank you very much.
Thank you for listening and watching this episode. We are looking forward to bring you more insights from maritime professionals, experts, and students. Do not hesitate to follow the podcast on Apple Podcasts, Spotify, and YouTube. Your support means a lot to us and helps us to bring you more content.